All right, good morning. Welcome to the training session board conducted by the Estate Police Association. We expect two members from the Ministry of Labor to join us shortly, the official part of this session. But before we get to that, there's some administrative work we like to get done as we have some of the branch board members here. Each of you all will have a package given to you, manila folder, if you could just open it. All right, contained within that package is some of the forms developed by the association to make administering and tracking of grievances and getting the relevant information much more easier to get. So when we are proceeding to various levels, either the ministry or the court, we would not have to be constantly calling the branch board and the aggrieved for information. The information will already be there. But one of the most important documents is the first one up. Ordinary membership application form. Each branch board person should have several copies of this document on their person at all times when they're on duty. It's not for sticking away in your locker. You have to have it so anytime you encounter that comrade of yours who's not a member, you'll be pulling all this and presenting it to him. Because according to the association rules, you are not a member. We maybe have some moral obligation to handle a grievance if you're not a member, but we are not legally obligated to do so. And to handle your grievance in a short course, that means without not being a member, there's an additional cost to that. Because it is unfair for the association to take its resources that you all have been members for the association for years, to take up a grievance somebody who just walked in the door and may have to go all the way to the court. That, in my book, is not fair. But you want to sit down in the environment and enjoy all the benefits of having the association representing, but you want none of the responsibility or the cost. All right, so it is your duty as a branch board member and as a member of the association to get every non-member in your environment to join the association. All right, and in particular, if they come with you with a grievance, the first thing you need to do is to check to see if they are a member of the association. They are a member, tell them, I hear what your problem is, I sympathize, but we can't help you because you are not a member. If all they learn to tell them that, then the association will be spending resources on non-members all the time. Because funny enough, they are the ones that always seem to have a problem. The non-member. There are some more problems than members. I can tell you, the statistics in the association bear that out. All right, the next form is this document here. This is for existing members to update their existing membership information. All right, I can't stress that enough for our existing members to have their information up to date. Because when this is done, the products that the association has developed for the members, like the food drive, the membership card to take the discount, we will be able to have this rolled out to you all. Because if you don't follow this, you would not get the membership card and all of the products that the association taking its time to develop on your behalf, you would not be able to enjoy it. So, those of you in this room here, and I am sure there are, because I know so because I checked, who have not done this. So start with yourself and update your membership information before you go to the regular member. All right? You need to update your membership information. Set the example. And most importantly, the part about gathering the information. Everyone will have this form, grievance form for branch level grievances. every grievance that is undertaken by the branch, this document needs to be filled out for several reasons. One, for your own personal records, so you all could show the members in your environment what you all have been doing. Because it is right now, if a member come and ask what the association branch board in any environment has done for the last year, we could talk and talk, but we would not be able to show them anything. Right? We'll have no data to show them. So this is what it's about. And most importantly also, this is the information that the secretaries and the chairman of the branch board will use to compile their reports to submit to me to present to the central committee, because branch boards are required to submit a report to the central committee on the going-ons in their environment. It is not something that the association has regularly enforced, but I can assure you, for this term, while I am General Secretary, it will be enforced. Even if you had to give me a piece of paper saying all you do nothing, I want that. I want reports from each secretary of the branch board when the central committee time roll around. And trust me, I'll be contacting all you to ask all your faith, and I have all your numbers. Right? So that is a few of the reasons why this grievance form is important. Right? If you take a peruse, you will see some of the information that we are asking for. All right? Name of the employer, home address, telephone number. All right? And part 4 the document, proof of membership. All right? So if it comes to me and that box and take off, do not be surprised if no action is taken. Right? And next, we have what the branch board grievance referred to the national executive. Now, this form may seem nonsensical, but it is very important from a legal standpoint, because we have been asked in the past, when we take matters to the Ministry of Labor by attorneys representing the employer, why the branch board not here and the national executive. In other words, they're saying, in accordance to the act, the branch board is supposed to be here, not the national executive. And then we have to go through the explanation about the creation of the national executive, etc., etc. And then this is where this form comes important, where it is proof positive that the branch board has asked the National Executive Committee to handle this matter on their behalf going forward. That is why we created this form. So in case some smart enterprise and attorney decide to play legal games, we have this here to throw in their face. So it may seem unimportant, but it's very, very critical that this form accompany the grievance when you are bringing it forward. All right, any questions so far on any of the forms that I have shown and given a brief explanation on? Nobody, no questions? All right. All right, good boy. All right, well, lastly, we have the relevant bylaws, excerpt from the bylaws concerning one of the forms that I spoke on earlier about membership and having a cost attached to non-members coming into the association. We did this so you all can have it to show the non-members the cost of not being a member of the association should something happen to them. Because in my tenure as a member and a branch board member, I always get, I don't have to join because whoever the union get, whoever the EPA get, I will get too. But it's more than that. When they get short pay, right? When the charge costs them, when the charge transferring them alone and leaving their friend and them in comfort and the location, those are problems that the association has dealt with on behalf of the members. I mean, it may seem inconsequential, but these are the issues that has made your work life uncomfortable. And these are the things that the association, branch board, and executive does deal with on a regular basis. Right? So, for non-members, you have an issue, whether it's suspension or less, you'll be required to pay a $1,500 fee. Then that will be on, so we'll find out the page it's on here. Yes, page, the third page. So you see, while you could be paying $50 a month, and it will take you quite a few years to pay $1,500. You know? Now with you get a 5-day suspension, you either handle that yourself or put up $1,500 up front one time to deal with the matter. Which one are you think cheaper? Right? Because trust me, I just strictly enforce this, you know, because I'm looking for less work. I have enough work on my desk. So anything I could slide to the side, I slide in it to the side. So make sure that when you all bring grievance, they are members. And members for more than a year. Otherwise, tell them to work with some cash. And then, in the second paragraph on that same page, if you're terminated, well, definitely that would most likely go to the court. So you have to pay that $3,000 plus get your own attorney or consultant. Because the association definitely not taking its resources to go to the court to pay a consultant a minimum of about $10,000 on your behalf, and you just walk in and want to pay $50 going forward. That ain't happening at all. So encourage the individuals in your environment to join. Those who refuse, I recommend that you take the name and put it in a notebook. So when they have a problem, you could just refer to it and say, but yeah, why you actually join? And you say no, so here what you got to pay your money, boy. Because a lot of them don't tell you no, until they have a problem. Because like this week, I received a call from, my second call I received from that member from my environment. Never joined, been asked to join, but you have a problem now because you see other people getting promoted in front of him. All of a sudden, you want to take up the matter. And he called me twice before the week out there. Never hear from him at all, you know. Yes, comrade.
Members who say they are financial and you could take your phone and call the EPA office, give a name and get a response.
Yes, thanks.
I appreciate that from the secretaries and all who work in the EPA office. That is commendable and highly recommended.
Yes, thanks for that piece of input there, Comrade Truly from Amalgamated. And I really should have mentioned it too. When that member come to you, 658-2293, call the Office of Financial Fees a member. Or, better yet, before that happens, call the office and get a membership listing for your environment and always have it on you. It comes like the agreement. You should always have a copy on your person. The membership listed on the agreement. That is what you should have on your person at all times. So the person comes there, the constable comes there, the first thing you're doing, check it to see if there's a member. And then they take it from there. Thank you for that, comrade. All right. So, I think that's about run through everything in the folder. And as Comrade Truly would have mentioned, and also one of the other things I would want you all as band board members, Comrade Truly would have spoken about having to call the association office to find out information on members who have passed. The association has developed and enhanced this benefit for members. please get that information. We have spoken about it. We have directed you to the website. We will give you all the information during the course of the day. Because right now, you all have a benefit of $3,000. We have enhanced that for what, $100 a year? For $100 a year, the member now will be entitled now to $20,000. Please utilize that. Because $3,000 now is like just to cover the cost of a week, a night for the week, that is all. But $20,000 could go a long way with funeral expenses. Right, so please bear that in mind. estatepoliceTT.com, that is the association website. Visit it. Encourage the members in the environment to visit. All right? And one more thing I would like to add about the grievances, although it will be covered by the ministry persons, and this cannot be stressed enough. The timely reporting of grievances. Within your agreement, there's a grievance procedure set up with the timeline. Please adhere to it. Because you all have no idea the difficulty it is in getting extension of time from the Ministry of Labor. It is becoming extremely more and more difficult because the employers are challenging everything at the moment. So whereas before it probably used to come a little more easier, now you had better have a damn good reason as to why you're reporting it late. Even a few days outside of the 6 months, causing plenty problems. Right? So please adhere to the grievance procedure in your agreements. Right? Right, so that ends my part of the program on the package. Huh? All right. I wonder if there is something. All right. Well, I'll pass you over to the president at the moment.
Morning all. We are awaiting the arrival of Ms. Gomez, the head of the conciliation unit at the Ministry of Labor. Just called that she is on her way. She just has to stop off at the Ministry of Labor office in San Fernando, right? The package that was presented to you, do you have any questions? I know we went through it kind of fast. Take your time, go back through it, especially like the grievance form and stuff. If you have any questions, this is the time for you to ask those questions, right? Don't go around wondering. This session is really and truly an information session so that we can have everything out in the open. So please, if you need to ask a question, just raise your hand and we will clear up any of the questions that you may have. So you go back through your documents, give it some time. If you have any questions, please raise your hand and we will answer it. Okay? All right, thanks.
I just want to say the rules, it need to be enforced more, especially in my environment. I mean, we just talk about the rules and everything, but I find the rules will be enforced. Because officers know what they have to do, and they rather spend $50 by a bar, right? And spend that $50 to come and pay the association on a monthly basis, and then the association does bend itself backwards to help these non-members. And I, especially in my environment, in a management, I reach out to the point where we need to start to enforce for them to get on board. Because the only way that things can happen is if these rules enforce and they realize, well, wait now, this thing is a serious thing, because officers taking the association for joke. Right? They want to pay the money, but as something happened to them, they run into branch board members, they run into the association. So it's a good thing, but I just think that the rules should be enforced more and we should stop being lenient. For years, the association has been lenient on these non-members. Okay, thank you.
Well said, comrade. I don't think you will have anybody here who is not in total agreement with what they were said there. Right? So, Comrade Cook, well said. And this is one of the reasons why we're here today, to share amongst ourselves, because you are the first line of defense. They come directly to you and then they reach us. Okay? So, that is why we are asking you to have in your possession the forms. So somebody comes to you asking for information, or you go to somebody and encourage them also to join the association, which is very important. Not just to wait on them to come and ask you to join the association, but you also need to approach them and tell them the value in joining the association. Okay? It is going to be a tough task. You're going to have a lot of people outside there who are not going to want to spend that $50 and who are going to have all manner of things to say about the association. You just have to continue to do what you have to do. You have to develop a thick skin, right? Because ultimately, as Cook would know, and a lot of you will know, ultimately they have to come back to you, right? And that is something that we have catered for in the rules, and as the comrade says, we need to be more lenient, more forceful, in fact, in how we administer those rules. Having said so, it is this executive's intention to have a complete legal look at the rules. There are a number of things in those rules that we need to change. And it is the intention of this executive to have those rules looked at from a legal perspective, somebody who's in drafting rules, to have those rules cleaned up. Because what you have is a hodgepodge of things from different places, some of which doesn't really apply, and some of which is not well before the thing. So as things change, circumstances change, environment change, we need to look at that. So that is something that we're committing to do. We're really committing to clean up the administration of the Estate Police Association. Okay? So, I don't want to stand for a little while. Okay. Now, while we await the ministry, because the ministry is going to come and do their session, right? The ministry, the reason why we are here today, why we have been, since last year we did it first last year. Last year was the first time we did this. We brought the ministry on board, and we said that we needed to train you, the persons, the frontline persons, right? We partnered with the ministry to provide for you the tools for which you can assist your members. It makes absolutely no sense to any union, any association, any organization to have people involved at that level and not train and provide them with relevant information with which to do their jobs. It is simply madness. I can say without fear of contradiction that we are basically the only organization in the labor industry right now that is taking this particular action where we are bringing you together to train you, to give you relevant information so that you are better able now to dispense your responsibilities as EPA branch members. Understand this, the industry we know, the industry you all are part of, there are many challenges to it right now. Many challenges for your officers, to your members, and they will come to you. More and more, there are different challenges coming out. We spoke about the Private Security Industry Bill. you have a lot of things coming out of that. We try to discuss that. You have issues of infringement on terms and conditions. More and more you're seeing things coming out from grievances, people coming for a number of grievances. You have a lot of issues concerning absenteeism, right? You have companies now looking for the cheapest way to dispense with your services. There are certainly a number of challenges. People will come to you, they don't know, understand that they don't know in the first place. Something has happened to them. It's your responsibility to assume from the first instance that they don't know, right? They will come to you, and a lot of time they will come to you with some information that they gathered from some destroyers or some people who think that they know. But when they come to you, they expect that you know. So that is what we have to do to empower you now. So when they come, you are able to analyze the exact nature of what the person is coming to you with. So you can now dispense that information, you can now take the records and move forward to be confident that you know what you're doing. Many of you would have signed on because you have an interest. You think that what is going on, you do not want that to continue. You think it's unfair. But some of you all are not told with the relevant information. That is what these sessions are. So you have one session today and another session on the 29th. It is also important that you take notes, right? It's important that you take notes, and it's also important that you keep reinforcing what you have learned today. A lot of you would have been here in the last session, and I'm glad that you came back because it's a reinforcement. And you don't learn everything in one session. Period. None of us do. There are things we would learn, there are things you would learn, there are things you would share with us that we would learn from. The ministry when the officials come, they will tell you that also, that there's a learning curve with that. So, what we want to achieve is a high level of competence, bearing in mind what our challenges are. We want to support you. We want you to know that you can call the association and have a conversation and advice. If you don't know, you don't know. Call and ask. There's no harm in saying, listen, I want some assistance. That's what the executive is here for, you know. That is part of our responsibility to bridge that knowledge gap. Because when that person comes and they say that the supervisor has not paid them, and when you ask for the information is still dated. They come 6, 7 months after, 8 months after, right? They have done nothing. You have to be able to discuss that. Tell them what are the challenges, what you will have to do. Even before that, you need to educate in little silos. Tell people what the process is. That 6 months before to report a matter to the ministry. After that, you will have to go for extension of time and all of that. You need to have that information at your fingertips to be able to dispense that. And once you could tell them assuredly the correct things, you will find that you will get more and more confidence in yourself, and the people will get more confidence in you, because when they recognize when it goes somewhere that what you would have said is the correct thing. Right? Now, we set up a number of things in the association where you can communicate with us. And one of the things that is going to be rolled out in the short future will be a WhatsApp number. Right? So we want to have a number of platforms where we can communicate and receive information and dispense information with you, right? Somehow we want to do 2 numbers. One of the numbers were specific to branch boards, right? So you will have branch boards and you will have the general membership. Because the general membership is going to have 1 million and we can't answer everything. But we want the branch boards especially to have that support, to know that they can call, and one of you will call, you'll call me, Southie, will call me, they will call any one of the executive. You need to know who your executive members are, the numbers. We have to make ourselves accessible. You also have to make yourself accessible, okay? I want to go into something from a larger standpoint. We have been spoken to about retrenchment. at a particular company, which I won't call right now because we are in the early stages of discussions. It's a state enterprise. And we have stated before that there is a serious challenge to state enterprise better paying jobs by certain elements of the private security hierarchy. We all know who he's speaking about here. Mr. Cook and his cohorts amalgamated. Now, one of the things that management has been using successfully in various companies is the issue of cost. Cost is an issue. They've also been using the issue of cost in relation to overtime. Okay? So those of you who are in, especially those who are in the in-house, in the state companies, are challenged right now by that. Because you have a lot of people who stay in home, excess, and causing overtime, and the companies are now using that to justify the need to hire private security at much lower rates. What it does is pauperizes the entire thing. There's nothing for us to juxtapose one against the other. The market rates goes down. We know that what Amalgamated did at TSCT, they bid $24 for a contract, when the contract, in fact, is $25 because they pay an state police officer $20 an hour plus $5 an hour for a firearm. What they did to control this entire industry, they bid under cost, their cost. So it means that your companies who have to bid against them cannot sustain that sort of price. And they will ultimately take over this entire industry. And we said to all those managers that speak with us, we are not listening to you once again anymore because you all have been remaining silent, so silence means consent. Not so? So if you say nothing and your business is going to go wrong, they are going to come and buy you out, and there's going to be a serious monopolization of the private security industry in this country. Me and you and I, together, we have to let our voices be heard. We have been on the radio for a number of years now. That is not sufficient. People will listen, and as one commander would have said, we hear you, but we're not seeing you, because nobody is coming up, nobody is standing up. Even your own companies, people are afraid. Victimization is real. Everybody is afraid to lose at the work. People not even afraid to lose their lives. Even at the Commonwealth and Allied. What happened on the 19th of September 2022? Immediately after that, the same persons in the same environment went out in the same vehicles to do the same duty for the same money. And we sent out a call publicly to ask all estate police officers who have expired vests to first raise it with your management or contact the association, give us the information. You don't need the names. You need your company. You need to have the information that the expiry dates on your vest. So we can contact the company and say you have 10, 15 vests. Imagine a state company finding vests from since 2005. 2005. 17 years. Man have a vest. That's paper. That is paper. We had a company in South. When they call the morning, the manager called the morning, asking my assistance, what for what? Because the duty refused to go out. Why did they refuse to go out? Because they feel vests are expired. How long the vests expired? He told me, he think it's 2 years. Call the guys, the banks board. I'm hearing this, give me an update. Say, Chief, you're going to send me some pictures. Send the pictures to me, 2005, 2004, 1989. Right? And people carrying vests. We immediately shut it down. By the next evening, there were vests. So you don't tell me that you could buy vests all the time? But because you all are sitting down and are allowing that to happen and looking for somebody else to blame, that is what happening. Your vest is 5 years to expiry. If it is stored properly and if it is taken care of in your private, it could extend past 5 years. But you know what? You need to test that vest on the range. So we tested the vest on the range. And if I could have shown you, it went straight through. Straight through, front and back of a 6-inch panel. Okay? This is what is facing you. This is what you have to talk about in your environment. You have to go. When you see somebody with a vest, ask them to see the expiry date of the vest. Ask them if the vest expired or not. That's what you need to do. When you, Barnes board members, have vests that expired, what that says, if you are the Barnes board members and you walking around with expired vests, what that says, you agree with the company? You agree with the company to send you outside there to risk your life for $17.50, $18.50, $19, right? That's what you are agreeing to it? Now, I don't know if you all know, but the families of Comrade Stott, Comrade Jeffrey Peters, and Comrade Baptiste, they're traumatized still. Mrs. Stott, she lost two sons. And these circumstances upon which she lost this one is extremely, extremely difficult. Extremely, extremely difficult. We have Mrs. Baptiste, strong woman, scarred from that. Scarred from that. That is a traumatic experience. But yet, the next day, you had people going out. We have people going out. That's amazing to me. We have Jeffrey Peters' wife. Recently, we still lending support to her. We had her come to the office here to talk with a lawyer and to get some things done because she's left alone with not 2 now, but not 3. And she's given me permission to say it publicly. Jeffrey Peters' wife is pregnant with a child that he did not even know he fathered. At the time of his death, she was pregnant. Let that sink in to all you. What it is happens to families. You disregard, you say, oh, them fellas got shot, everybody, 91 in this country. Everybody was. Oh, this and that and everybody wanted this and want to jump on a bandwagon and be very indignant and talk about the private security. You have all over the radio stations. And it has died down. I know why does that? Because you are the ones that lie down. Because you still going outside and then there to do that. You still going. We have to call Mr. Otley Company and shut down a number of things. They're fixing everything now. CDA, we have to go public on the radio, right? They're fixing everything now. The only time they fix things is when it reaches critical mass, and you are the persons to bring it to critical mass, not us. You bring it to us, we will take it where it has to go. We show that we have the body for the fight. But if we don't get that information, I cannot walk and see what your vets have on it. I don't know that. But you know how that particular thing happened? I was driving through Hoover, saw this particular vehicle pull up to do a cash in transit. The vest improperly fitted. The how they come out was a mountain, so the place full with people, all the car park full of people, they could hardly get a car park. Hardly get a park. And they walked in among the people. I wrote to the CEO of the company and made a complaint. And out of that, now the Barnes board did their due diligence and they went out far and wide and found vests 2005, 2002, 2005, 2004, 2006 expired. Right? And And after that now, everything getting fixed now. They want to know who to buy vest from. That is the only way, people. Your health is your wealth. You cannot make a duty dead. Can't make a duty lie down in Mount Hope. Your family is going to be affected if you are not present. So protect what little you have. Protect your family. We are begging and beseeching you as branch board members, be very diligent about these health and safety aspects in your environment. Please ensure that your company under the OSHAC, there is a requirement for you to have a security, a OSH community. Police that. Make sure that there is one. Make sure that you are part of it. Make sure you attend meetings. Right? Make sure you attend meetings. So, I think when you lay that foundation, see Ms. Gomez, head of the conciliation, you want to welcome her one time. Ms. Gomez, thank you very much. Alright, so let's lay that groundwork. So Ms. Gomez will come and she will dispense for you with you the tree. Mr. Healy? Good.
You know, by now we will have a lot of questions, and questions we look for answers to because of the environment we're not going to be facing. Now, we on this side know that we cannot represent non-unionized members. In my case now, pertaining to the bulletproof vest, I have a lot of men who can be bad by me, who not union CIT, who not even unionized, and when it expires, and I can tell them how long it expired, including myself. But what I see happening is that they're changing the outer part of the vest and making it look new. So when I went to my manager and I told him, I said, I wash my inners, and when I check my vest expired 10 years. 10 years. Now, I am to blame, just as you say, because I was part of this shit that's going on. But one of the things that I really want to highlight is the human resource part of our company. I want to know if, when they change manager, or the structure changing that has led the EPA. Because one instance, I had a human resource manager telling me that we will have a meeting via Zoom. And I had to tell them, boy, stop your madness. Because how you can have a Zoom meeting with me and I drive you? And he turned and told me, the manager said, he cannot afford to give me that time off to come down meeting and say, yeah, what about? You do what you have to do and let me do what you have to do. Alright? So this is my feedback to them on that level.
Alright. Before, we may answer this question before, right? One, the issue of life and death is not a membership issue. Let me pass that one. Let's pass that one. The issue of life and death is a membership issue. Because that person, even though they're not a member, they have a family, they are a human being. And you're still reaching out. Still reach out, and you provide the information. Provide the information, and then we will deal with the information. Okay? Concerning whether or not they're not obligated to inform us that no change in management. Right? There was some point in time, via letters, we will see certain things come and realize certain things change. Right? So, but in the instances in different companies deal differently. Some people will write us and say that this person is no longer here, and some people would not. Right? Yeah? So, it's training. Are you training or which one? Or Debbie? No. All right. Let me just clear it up again. If you're not an estate police officer, you can join the association for full membership. You can join the association as an associate membership, so you can get access to the things that we have, the health plan and all of that, right? But for representation, we cannot go to the court for persons who are not estate police officers. Right? Okay. So, without much further ado, I want to introduce to you the conciliation unit at the Ministry of Labor. Her name is Ms. Sabina Gomez. She has been partnering with us since last year and even before that. She's a great resource, fantastic resource, very helpful, very knowledgeable. And I would hand you over to her this morning, and I would relax for the rest of the day. Thank you very much. You understand what
Hi, fine, thank you. Good morning, everyone. I would like to thank Mr. No, I'm not sitting. Sitting off at work. Mr. Richardson and Mr. Utley and the executive for, inviting me. And worker education is always very important, and especially as you all are branch representatives, and there would be a certain level of expectation when workers come to you. And we hope to be able to impart to you, and we want the session to be very interactive. No question is a wrong question. You feel free to ask anything, and we can have a discussion, right? To teach us always to learn sometimes, and we can learn from each other. Right, so what I want to touch on today, I'm going to go through in terms of the reporting of trade disputes. Because sometimes when you are branch, is the reporting of the trade disputes, it will come to the executive after you would have gone through your grievance procedure and all of that. So to give you an understanding of time frames and when matters are statute barred. So when you have the responsibility, it's not just you're talking, and then a year after, you're going to the executive and then the matter statute barred and you have to apply for an exemption. So we're going to go through all of these things, and you're going to have the opportunity to ask questions. Oh. You don't have a clicker? You don't? Yeah. I can't. Oh. All right, but I'll have to use here. I'll have to have my back turned. That's all. No, but he's not finished as yet. Information may not be applicable to you, but the knowledge is always good to have. Right, it's still a little, yeah. The reporting of disputes to the minister, and we're going to go forward. Right, so in the case of, I'm going to go through the pieces of legislation that individual workers can report trade dispute. Under the Retrenchment and Severance Benefit Act, under the Maternity Protection Act, and under the Minimum Wages Act, individual workers can report a matter to the minister. Right. Now, in reporting matters to the minister, the IRA is the pivot. So you would find that when you're reporting a matter, if it's an issue arising out of maternity, say for instance, the EPA wishes to report a maternity matter, they will have to come under the Police Supplemental 51(1) and the Maternity Protection Act. So you have three pieces of legislation that you're coming with, right? So the IRA, most of the legislation will point you through the Industrial Relations Act. So sometimes you report and sometimes you have multiple, you have to touch on each section of the act that you can come through or to have access to the IRA in terms of to report trade disputes. Are you all familiar? Do you all have your legislation? Familiar with who would have legislation as a branch officer? You all are all branch officers, right? Okay, so you all have legislation. What do you have? What do you have as your tool? Huh? No, I want them to answer. You all are the ones that will be helping workers when they come to you, right? Okay. How many of you all went Cipriani? You finish? No, you must always start, you must always finish what you start. You did the 10 Saturdays. So nobody else? You see, because when you're representing workers, it's people's lives you're dealing with, and issues are not to be taken slightly, right? So therefore, you must have some foundation in terms of what the law is, time frames, and all of these things. All right, so. Right, so what is the role of the Conciliation Advisory and Advocacy Division? Right, some people call us, they still call us the Labor Board. I'm going by the Labor Board. That would have been probably in the probably 50s or something. Right, before it had a Ministry of Labor, there was a Department of Labor. And matters used to be, they had industrial advisors. I think Sir Solomon Hochoy, well, he wasn't Sir Solomon Hochoy then, but Solomon Hochoy was one of the advisors in the Labor Department. Right. So, So, Trinidad and Tobago, we promote advisory services. We provide conciliation services. When matters are statute barred, we process extensions of time. We draft policy, and one of our main policies is the sexual harassment policy, the workplace policy on sexual harassment, which will soon become law, and which I would want to touch on after this session, because it's very important, because there's a draft bill that's out, and it's jail and fines all the way around. No one or the other, right? So it's important that you know what's in the draft bill. So what I will share what's in the policy, I would share what's in the draft bill, and then I would do some case law with you. Right? Now, we are involved in a lot of other issues. Anything that pertains to the employer-employee relationship, we also do have mediation services that we provide. Employers would call us if there are interpersonal relationships on the job, broken relationships, and they don't want to dismiss the person, they will call us in. We have certified mediators on board. Who would be able to assist. I think I need help with this, We go to who can report a trade dispute to the minister. So all disputes are reported to the Minister of Labor, right? Not the permanent secretary, the Minister of Labor. The Minister of Labor is the chief conciliator. And he has a dual function as a cabinet minister and also as the Minister of Labor. So if you find there's anything being discussed in cabinet that may come to him as the chief conciliator, he has to recuse himself from cabinet for any part of that discussion on any matter that may come to him. Right? That may come to us and it's being discussed in cabinet, he has to recuse himself because he is the chief conciliator. Right? With who? With your manager? Well, we're talking about the administration of the whole process of labor administration. If you No, we're just going through in terms of labor administration here. We have time if you want to ask an individual question, right? But we just strictly speaking with what's in the legislation and our role and function, right? We can take individual questions after, right? So hold it and we'll come back to that. Right, so you have under Part 5 of the Act, you have 51.1, so trade disputes are reported pursuant to 51.1. The employer could report a trade dispute, the recognized majority union, or C, where there's no recognized majority union, any trade union of which the worker or workers who are party to the disputes, right? Now I heard someone asking a question about, once you're not precepted, or the EPA security officers, right? If you are not precepted, then the estate police cannot represent, right? So I guess everybody would be aware of that, right? But workers can come under Part 5 of the Act, under 51.1C for a walk-in client, right? Anyone who can walk off the street and seek representation from a union of their choice to have their matter brought before the minister. Can someone help me? Yeah. We're looking at the types of disputes that come to the minister. Any dispute between an employer and workers of that employer, trade union, there's a definition of what a trade dispute is in the Act. Now, sometimes disputes are reported to us that they don't fall within the confines of what a trade dispute is. And sometimes we take it because, things like verbal abuse and, if we take it because there's something going on in the establishment and, workers are crying out for help. So we do take it. And I think because, and the court would accept it if it reaches as far as the court. Sometimes the union will bring matters, not because they wanted to go to the court, but they want a third party, an independent third party to probably pull the employer aside and have a chat with the employer or to advise on issues. Sometimes matters come to us not necessarily to go to the court, right? But they want the conciliator to say something. It could be that they want the conciliator to speak to the worker, right? It could be that they want the conciliator to speak to the employer. And so, roll of card, that's it there. Presentation, roll of card. That's it. This one here, roll of card. All right, so, sometimes unions report matters like wrongful termination. Some unions love the term wrongful termination. Wrongful termination is common law. It means that you did not give me notice. So therefore, if I was an employer and a union reported wrongful termination, I would be very happy. Then I would say, all I will give you is notice, right? But some unions, they're steep in tradition. I don't know where they picked this up, unlawful and wrongful, and, they report these things. But wrongful termination is for the High Court. Unfair termination is what is for the industrial court, right? Right. So let me see. Right. Yeah. Right. So the disputes can be broken down into you have your rights disputes and your interest dispute, right? Interest disputes dealing with your terms and conditions of employment, and your rights dispute could be, a dismissal, warning letter, suspension, these things that would arise. And then dismissal is broken down even further. You have verbal dismissal, you have written dismissal, you have constructive dismissal, you have, what other types of dismissal you have? Well, now you're being dismissed by WhatsApp. So you have different types of dismissal that is being utilized, with the advent of social media and all of that. Employers no longer write in the WhatsApp in your dismissal. And, sorry? You can't see the screen properly? Where's IT guy? Anybody could fix it? That's how it is? You sure? It probably need to be placed on a height or something? That's the best. All right, okay. I will try to read it out, right? What else? Dismissal, constructive dismissal, suspensions, issues arising out of sexual harassment complaints, verbal abuse, non-renewal of contract, unilateral variation of terms and conditions of employment, non-payment of gratuity, non-payment of overtime. Now, this just by the way, if an employer is forcing you to sign a document, always sign that document without prejudice. Right? Sometimes, it's a take it or leave it situation, and you may be in a position where, look, you really need a job, you really need the money, and even though it's not favorable to you and you're being forced into it, you always sign without prejudice. Right? That means I reserve my right to take up any other matter further concerning this. Right? It's a little by the way. So now we're going to look at statutory time frame for reporting a trade dispute. Now, there are always statute of limitations in everything that you do. In almost legislation, you have a time frame. Right, so there's a grievance, you may go to the branch, and sometimes, you may be busy, so you may not take it up right away. And, time pass, we talking about the situation, it's not getting any better. And, you keep talking to the supervisor, you're talking to this one, by the time you know it, 6 months gone already, by the time it reaches the executive, it's because the matter started bad. So once you're addressing the workers' matters, you have to be aware of time frame. The day the issue given rise first arose ought to be your favorite friend, because that's the first thing you ask. Because a lot of matters are reported to us, and sometimes the day the issue given rise is a challenge, because sometimes the worker don't even know. The worker will come to you, and he's not even aware of time frames. When did this happen? When did this happen? So sometimes matters come to us, and they get thrown out because there's the wrong date of issue. Right? So the matter may be reported to the minister if not more than 6 months. So it has to be within that 6-month time frame. And it's always good for the union to report the matter prior to the 6-month period. Right? Because if the union report the matter on the last day and something wrong with the dispute, it have nowhere to go. He'll have to go back and apply for 51(3). So always give the union, that wiggle room, like 2 months or something like that. So in case they come to conciliation and there's some inconsistency with the dispute, they could always pull back and come again without having to apply for 51(3). Right? So time frame is always very important. Don't lapse in terms of having the matter come to the executive. Right. Now, preliminary issues that could raise, sometimes the employers could raise, An employer cannot raise the membership in good standing question if there's a recognized majority union, right? If the worker falls within a bargaining unit, the employer cannot raise that. It comes like a client-lawyer relationship. You can't come because that is not your business. Whether if the worker in the bargaining unit and you feel that the worker not paying dues, some employers will come and raise the question because they know that dues not coming out from this particular employee. But once the union and the worker have whatever arrangement they have to for representation, the employer cannot raise the membership. And I think it was intended that it will only be raised in a situation where somebody walk off the street and seeking representation, right? The worker question, I think with the EPA, I think you'll never had the worker question raised, you sure? Oh no, right, yes, I understand. Yes.
We are what is called a recognized association. Once we establish a branch order, we are going to be recognized by the employer.
Exactly. Right. Exactly. So you see, Mr. Otley clear that up. Right? So now things that preliminary issues that could be raised during a conciliation. Incorrect date of issue. The matter is statute barred. Incorrect employer. Proof of service. Successorship. And the reporting party jumped the gun, they didn't follow the grievance procedure, right? So those are the kind of issues that would be raised in conciliation as preliminary issues. Any questions so far? Right. So you have a 6-month period to report a trade dispute. All right, so, hi. All right. When you said they are not, they do not belong to the EPA, or they're not paying the dues. Well, as the branch representative there, you come like the grievance officer there on the job. So if you see a matter that needs to be addressed, you deal with it. So you're walking into your role then as you know, taking up a grievance and addressing it, because it may not affect your member now, but it could affect your member later on. So if you see something, and even though the person not paying the dues, that maybe that could be some way of encouraging them that, look, you know, look, I have an officer there and the officer is working on my behalf, and look, I ain't even paying dues. So all these things will assist in bringing people into alignment in terms of paying the dues, right? I'm always a firm believer. Ever since I joined the service so many years ago, I've always paid my union dues, never dropped. You know, people need to be encouraged to pay the union dues. Yes, that is, and I know that's our biggest problem in Trinidad. People don't like to write. They will sit down and talk. They're talking to the supervisor for how much a year going by and they're still talking. And at the end of the day, they have nothing. Where's your evidence? You know, I always say if it's not written, it never happened. Well, why not take it to the police? Why not take it to the police? All right. Well, sad to say, but the legislation would treat with all of these things. And the draft bill has reached an advanced stage. You just have to work out a few things. But all those things, you know, should be addressed when the legislation comes on stream, right? Because sexual harassment and sexual abuse, especially in the security industry, is very prevalent. All right, so I was going to ask the question. Right. So I was going to ask the question. Now we're talking about the day the issue given rise first arose. Right now, back later. Now, I think I'll give an example on the last, so I'll do it again to this session. A worker was dismissed on, what's the date? What's the date today? Today's the 22nd. On the 22nd of March, the worker was dismissed on the 22nd of March, right? Today the worker went to work and the employer say, well, you know, I no longer need your services. Today is your last day. All right, so we're talking about matters being statute barred and there's the 6-month statute of limitation. So what would you advise the worker is the last day that he has in order to report the matter to the minister? 22nd of March. What's the last day? Okay. Who else? '22nd of March. When does the 6-month period? Because that's one of the things that you have to know. If somebody comes with a complaint, you have to find out whether the matter is a live matter or whether it's statute barred. Right, so the 6-month time frame. So how would you check the 6-month time frame? You know, sometimes people have a grievance and they keep it long, and then something happen and it trigger them and then they come to you for you to pick up the matter. But when you ask them, but this matter real old, right? So how are you all going to check? Because that's one of the first things you check, whether the matter is statute barred or not. So I give you a date, the 22nd of March. So I want you to tell me what day the matter will become statute barred. Huh? Okay. We have the 22nd of September. Takers. What day the matter will become statute barred? 22nd of March. The worker was dismissed 22nd of March. What day the 6 month will expire? What day is that? Okay. So what day will the matter become statute barred? 23rd of September? All right. Anybody else? What day you say? 21st? What day? Anybody else? No, we're talking about a matter is alive for 6 months, right? The worker was dismissed on the 22nd of March. So if the worker was dismissed today, right? Today is the 22nd of March. How much time the worker will have? When is the date that the matter will become statute barred? Okay. Okay. Anybody on this table? How would you check? Because that's one of the most important things to check to see if the matter alive or not. September the 22nd. All right. Doesn't matter. Suppose the worker working on a Saturday. Okay. 22nd. Okay. All right. So, in checking whether the matter is statute barred or not, what we look at, and there's a piece of legislation called the Interpretation Act, right? The date to date and the day after, the matter will become statute barred. So if it's the 22nd the issue occurred, the union will have, the association will have up to the 22nd to report the matter. On the 23rd September, it becomes statute barred. Right. Now, if it falls on a Saturday, the Interpretation Act again, or a public holiday, Saturday, Sunday, or a public holiday, it goes to the next working day. Right? Okay. 23rd. Right, but in the security, the 23rd may be a working day, right? But for reporting purposes, if the last day fall on a public holiday, a Saturday or Sunday, you have the day after, which is the next working day to report, right? So that you get that from the Interpretation Act, right? It's a piece of legislation, but it's good to have as if you want to become a professional, a practitioner in this thing, then that is a good piece of legislation to have. Oh, they shifted. All right. All right, so if it's January 1st, 2018, the reporting party has up to July 1st to report the dispute. Failure to report the dispute would result in the matter becoming statute barred on July the 2nd, right? So date to date and day after. I think this was a matter that went for interpretation to the court because in times past, people used to, if it's the 22nd and the 21st, right? But the court would have dealt with that in terms of giving an interpretation. Now, this is for knowledge. We spoke about, now this would not apply to you all, but matters do go to the Registration, Recognition and Certification Board as preliminary questions that employers raise when matters come to conciliation. So if and it's a way of, sometimes it's not genuine, and sometimes it's just a way of frustrating the process. The employer comes in and raises membership or worker. This person is in charge of a division. This person has effective control over these various positions. So what that means is that you don't have access to the industrial court, but you have to go to the high court to take up your matter. Right. So we're going to go into what happens after the dispute is reported to the minister. So, as the branch officer, you have picked up a matter, you have done gone through the grievance procedure, and you have now submitted the matter to the executive for them to report the matter to the minister. So what, let me remove this screen. All right, so let me hear in your opinion, what do you think happens when the matter reaches the minister? All right, what else? Anybody? Anybody ever had a dispute come through the ministry? You? So you came to you said mediation. All right, anybody else? In terms of what do you think, based on your knowledge, based on conversations you may have had with persons who may have had matters come into the ministry, what do you think happens when your matter reaches the minister? Okay, conciliation. When? Okay, why would we want to speak to the employer first? Wouldn't that be bias? Why we can't speak to the association first? All right, so in your perception, your belief is that we speak to the employer first. All right, anybody else? What do you think happens to a matter when the association brings the matter to the minister and they tell you that your matter reported? What do you think happens? And that's all? All right.
The minister receives it. She would contact the relevant.
She?
Or he or she would contact the relevant parties. For maybe 14 days or so, and have some kind of mediation to see if they can work it out somewhere around that way.
All right. Anybody else? Come on, I want to hear your views. Just say no answer is wrong.
Secretary.
Okay. Come on, this table here. You sound like you know plenty. You look like you know plenty. Come, tell me. Okay. All right, who else? Come on, don't be shy. Across there, carry the mic across there. No. No, that's yeah. Let me hear what he has to say.
All right. I think the minister will contact all parties and set a date for conciliation.
All right. Okay, anybody else? All right. So the first thing we do when we receive a dispute, we check the dispute to make sure that it is a valid dispute, that it is a proper dispute, that it check all the boxes in terms of if it fulfills the criteria of a dispute. So that is the first thing that we do. We validate the dispute, right? If it's deemed to be a proper dispute, then we accept the dispute, we assign it a trade dispute number, and then we acknowledge the dispute and we invite the parties to conciliation. Right, so you get a letter of acknowledgement and also an invitation to meet simultaneously. You get one letter, so that is the letter of acknowledgement. It is a legal document, right? You can take that document to the court and report the dispute, but not with EPA. EPA cannot do that because their matters go to the special tribunal, and the minister refers all EPA matters to the tribunal, right? So they don't have to go and refer their matter. There's something called, we have the unresolved certificate, and the referral goes directly to the court. So when the court receives the referral, it makes up the file one time, right? So once a dispute reaches the minister, we have 14 days within which to invite parties for conciliation. And one of the things that they get within the 14 days is either a letter stating inconsistencies with the report, and you will get that letter within the 14-day period. That's under section 53(1). We call it further particulars. So the minister has within 14 days to issue that further particulars to tell you if there are any problem areas within the report of the trade dispute. Right. No, hold on. Give her the mic. When you say the letter, what do you mean? You're speaking about the minister refers the matter to the court. Yes. Yeah. As against other rights issues or other matters that go to the General Services Division of the court. Now, the court is made up of the Essential Services Division, the General Services Division, and then you have the Special Tribunal. Well, other than the OSH side of the court, you have the Special Tribunal. Now, the Special Tribunal is a creature of the Constitution, and you have matters, persons who belong to the public service, the civil service, or the commissions, their matters go to the Special Tribunal. The Minister of Finance, he reports matters pertaining to public officers, public servants, civil servants. The Minister of Finance refers those matters to the Special Tribunal. Right, so the acknowledgement of the dispute is one of the most, if a dispute is not acknowledged, then it doesn't exist. Right, so that is the first thing the minister must do. He must acknowledge your dispute. Once he acknowledges your dispute, you know that your dispute is legally registered. If you don't get an acknowledgement within 14 days, then something is wrong, right? If there's no contact with the ministry, and if there's the EPA report a trade dispute and we find something wrong, we will write, but we would also put in a phone call and either speak to Mr. Utley or Mr. Richardson, make inquiries, let them know what we found, if they need to do more clarification or if something is missing. So we send the letter because we are required by law to do so. There was a Court of Appeal judgment with respect to the whole issue of further particulars, right? That's under section 53(1). right? So once we acknowledge the trade dispute, you will get an invitation to meet. Both parties will be invited to meet within the 14-day period, right? Now, the 14-day period that is within the law. It's a tight time frame to keep, and sometimes parties may not be available to meet within the time frame. We don't call parties anymore. We used to do that a long time ago, because if we call parties and ask them if they're available to meet, they will never be available to meet within the 14-day period. So we have to fulfill our obligations under the law and invite parties within the 14-day period. If you can't meet, then you can just shoot us an email and say, I'm unable to meet. However, I am available on this day. And when you send it to all the parties, the conciliator would be aware, the employer would be aware, and you would be aware. So we have a good email thread going on, and we try to encourage, persons to function this way, because, to save on time and effort, really. And expediency should be the first object, or expediency is one of the objects of the act, right? To be able to function in an efficient manner and a quick manner. Right, so that is regarding the first stages of the report of a trade dispute, right? So you should know, once the report reaches the minister has 14 days in which to act. So the two things that you could get, you either get an acknowledgement and an invitation to a conciliation meeting, or you get a letter requesting further particulars, and we send out everything via email. So if you have reported a dispute and within 14 days you have not received an email, something is wrong, and you need to call immediately to find out what has taken place with your matter, right? Okay, so everybody understands what transpires when the dispute reaches the minister. And it's important that you know that, because you're representing workers who would come to you, and because you are the branch representative, they will feel that you would be aware of the processes of the system of industrial relations, right? Right, so you see I had it, step one, the minister has 14 days after the trade dispute has been reported, or in your case, the dispute has been reported by the association, to acknowledge receipt. Within the 14 days, the minister invites parties to the Ministry of Labor for a conciliation meeting, or if the dispute is not a proper dispute, before the minister under pursuant to section 53(1). The matter is conciliated before a conciliator who functions under delegated authority of the Minister of Labor. Right? So we are what you call a neutral third party. Now, once we write you and we say, look, we seeking clarification of the nature and scope, or you left out the date the issue given rise, or there was some shortcoming. Now, once we send out that section 53(1) to you, the time stops. Right? The time stops. Now, when you send back the correspondence, right, so the time starts back from there. Right? So it's no more 14 days from the date you previously submitted. Right? So the time stop. But when we send for further particulars, parties must always be mindful of the matter becoming statute barred, because sometimes we write for further particulars and we don't get back a response in a timely fashion, and then the matter becomes statute barred. Right? So when we send out the 53(1), if we put it in, if we write you, then we would also sort of give you a little nudge and tell you, we would look at the date the issue given rise, so that is why we put in a phone call, because we really don't want the matter to become statute barred, right? Other than it being more work for us, we really don't want it to become statute barred. Right, so let me ask the other question. All right, the matter is now reported to the minister. We invite parties for conciliation. What do you think happens in anybody have ever been to conciliation? Well, newbies here, boy. You have never been to conciliation? All right, pass the mic. He has been, so.
their case and then it will take it from there.
All right. Now, the format of conciliation, anywhere in the world you go, it's the same format that it's a practice, right? It's similar to mediation, right? You will have even the structure, the way the room is shaped, anywhere in the world you go, that conciliation or mediation is practiced, you would see the same setup of the room, right? The conciliator would sit, and then it's a L-shaped, parties on either side, right? So the union is the majority of the times is the reporting party. So they will be asked to go first because they're the reporting party. They're the reason why we're here. So you want to hear what the dispute is, right? So there's a format, a procedure that is used in conciliation. Parties will introduce themselves. You know, you would state how you would like the meeting to go. You know, I think in our situation, conciliation is very, it's very structured, it's very civilized, it's very, civilized is probably the wrong word, but it's very structured is the word I would use. You know, in other jurisdictions, you know, you will have chaos or something like that, but in our jurisdiction, it is very structured in that, you know, parties coming to conciliation, they have been doing so for a while, so they're familiar with the process. So we don't have any, I mean, in times past, before we came into conciliation, I know there was a lot of violence associated with the job. You know, we had iron chairs, and sometimes in conciliation, people pick up the chairs and pelt it. I saw, you know, you'll have a lot of foul language, and now, you know, conciliation has, you know, evolved. You know, it's very civilized. People come to make submissions and all of that, but long time, you know, when we were purchasing chairs, we had to be careful about the type of chairs that we bought, because sometimes in a meeting, a chair would just fling across the room. So we had no more iron chairs. So we had to go with, you know, these ergonomic chairs. And I recall in a Bermuda's matter, Bermuda's OWTU, Mervyn Trumpet was the officer. I think he was from either OWTU or Amalgamated Workers, and he walked St. Vincent Street and beat Andre Jessamy. And Andre Jessamy is a big giant of a man, and he must be 6'7", 6'8". And Mervyn Trumpet is a small man. He probably like about 5'5". And he walked behind this man. He was the attorney representing the company. And he beaten Mr. Jessamy walking up the street. And Mr. Jessamy just had his briefcase, you know, just hiding his face walking. Mr. Jessamy wanted, he could have just swipe and get rid of Mervyn Trumpet. But he never did. He just took the blows and he walked up St. Vincent Street. I think they got police protection for him next day. But, you know, the industrial relations climate, it has evolved. And so you would find that conciliation is very structured. But the standard has fallen a bit, I must say, since I came in. you find that persons coming to represent workers, they're not prepared. I mean, you find that they're more educated in terms of in times past. You know, I could recall people like Mr. Boring and from National Union of Government and Federated Workers. You had Frank Webb from Communication Workers Union. His favorite phrase was, the candle will cost more than the funeral. And you had James Jones. Mr. Jones had a famous thing he used to do. He used to always turn up